Good afternoon to everyone. We want to welcome you to the Tennessee Court of Appeals. This afternoon, your panel consists of Judge Frison to my right, Judge Davis to my left, and myself, Judge McClarity. I understand that there are many represented parties on these cases, but I have not received any motions or requests for extended of time for argument. Have there been any filed that the attorneys would know of? No. Okay. In that case, then, we will proceed in a normal manner. That means 15 minutes per side. Okay. I want to make sure that you understand that these proceedings will be recorded and are recorded, and they will be on record. So we ask that you please watch and make sure that you don't say something you don't want to hear about later on. Okay. Okay. Are there any preliminary matters?
No, Your Honor.
In that case, Madam Clerk, will you call the first case?
Clata, Renee, Brewer et al. Versus Metropolitan Government of Nashville and Davidson County et al.
And for the appellant? I assume then there will only be one argument on this side, right?
Correct, Your Honor.
Okay, then. And your time for rebuttal?
With the court's permission, 4 minutes.
4 minutes? That's correct. Okay, then. If there's nothing further, you may proceed.
May it please the court, my name is Paul Krogh on behalf of the petitioners. The trial court held that the Tennessee Public Records Act was preempted by the Copyright Act of 1976. Mm-hmm. No federal court and no appellate court in any jurisdiction has ever held that the Copyright Act preempts an Open Records Act, and the trial court was wrong to do so and should be reversed. Implied conflict preemption, the species of preemption invoked by the trial court, applies when a state claim or a state law impairs the exploitation of rights conferred by the Copyright Act or interferes with the proper functioning of the copyright system. And that's a standard taken from Jackson versus Roberts, Second Circuit opinion that we cite in the briefs. And two, if that claim or law doesn't further a substantial state interest distinct from copyright. Now, generally, this occurs when some state law modifies the array of rights the Copyright Act creates, such as by allowing someone, again quoting Jackson, quote, to exert control over a work within the subject matter of the Copyright Act under a mechanism different from the one instituted by the law of copyright. What's curious here, Your Honors, is that this is precisely what the trial court's ruling does, not what the petitioner's claim seeks. And we can understand this if we look at the detailed opinion from the Northern District of California, also discussed in our brief, X Corp versus Bright Data Limited. In that case, the plaintiff sued the defendant for data scraping content out of tweets. And the claim was held preempted by the California federal court. And the court invoked 3 principles to demonstrate why this was necessary. First, the plaintiff's claims would have allowed someone other than the copyright owner to enforce a copyright. And as the Second Circuit noted in Jackson, that matters because a copyright owner has the right to enforce a copyright, but also the right to tolerate some infringement or other use of that. They have the choice to enforce or not enforce. Second, the plaintiff's claim in X Corp allowed prohibitions on fair use. And third, it would have allowed assertion of a essentially quasi-copyright over non-copyrightable materials. These were all defects, all things that the plaintiff in that case sought to do that interfered with, in the federal court's analysis, with the copyright system and required that those claims be preempted. And the claims in that case were all a diverse array of California state law claims. The trial court's order in this case does all 3. It allows public records custodians to enforce, to be the arbiters of copyrights, to withhold documents by asserting some third party's copyright claim. It allows for no fair use inquiry. And it doesn't allow for any document-specific analysis of copyrightability, even though that's required under the Copyright Act.
Let me ask you this. Is it your position that any issue related to copyright should be pursued in federal court, or is it your position that the trial judge in this case should have gone through the analysis in a typical copyright infringement case, such as is there a valid copyright, is there infringement, has there been fair use, or is there an exception to that?
It's our position, Your Honor, because of the way the TPRA reads, that the trial court should have abstained from that inquiry and said, if you want to enforce a copyright, go to federal court, file an infringement action. Now, there are some of the state court cases in other jurisdictions that go the other way. The state courts perform the fair use analysis because they have federal law carve-outs. They say, if disclosure would be prohibited by the copyright rules, then that's an exception to our open records law. We don't have that here. Because we don't have that, the trial court should have simply said, you want to enforce a copyright, file an infringement action. And that's actually the fourth sort of the bonus issue with the trial court's order here, in addition to the three noted in Ex Corp, is it allows enforcement by different means than the ones created by Congress. Congress created a system for enforcing copyrights, and that system reflects congressional policy judgments about how to do that, how to enforce those rights, and how you can't enforce those rights. And if we want to have policy disagreements about that system's allocations of winners and losers under a given set of facts, that's an issue for Congress. Write your congressman. So, weirdly, a state law claim, if a plaintiff came into a Tennessee court and filed a state law claim seeking exactly the same relief that the trial court awarded here, essentially to the interveners, that claim would be preempted. It would be barred by the Copyright Act. And that simply can't be the law. It can't be the law that the Copyright Act itself requires an outcome that it would preclude if the procedural posture were different. Another thing about this is it shows that courts can think about and analyze fair use issues outside the infringement action defense context, because the courts in those cases went through these analyses. They said, would this be fair use? Some of these uses would be fair. Some of these documents aren't covered by copyright. And we're going to consider that. We're going to do that analysis, even though this isn't an infringement action. No one's asserted an affirmative defense of fair use. We're going to think about those issues here. And so if the court were to disagree with me about how to deal with this issue and say, no, trial courts, y'all need to be analyzing these fair use issues, they could do that if that were what the law required in a case like this. And that's even laying aside the fact that the TPRA embodies important non-copyright state interests, the interests in open government and public access to the workings of public officials have nothing to do with the interests that the Copyright Act protects, which relate to the promotion of the development of literary and artistic works and the limited protections given to their authors. Consider the ramifications, moreover, of the trial court's order in this case, applied in other cases. Almost every document that is created in a public office, whether it comes into that office from the outside or is generated in that office, meets the standards that the trial court applied here of being minimally creative and fixed in a tangible medium. That means that this entire body of the workaday sausage-making documentation of state and local governments is going to disappear into this black hole of sort of quasi-copyright protection if we endorse the trial court's approach here, simply saying, if you meet sort of those basic threshold requirements of tangible medium and minimal creativity, then that's basically where the analysis ends, and those documents can't be disclosed. And those are what people care about. You know, the emails, the permit applications, the internal memoranda, all of these things that are going to show waste, corruption, favoritism, prejudice in state and local government, those are the things that no one's going to be able to get. And that's not what the mandate for the courts in enforcing the Tennessee Public Records Act is. It's to construe exceptions narrowly and construe the act itself broadly to maximize public access to public records. My friends on the other side talk about Attorney General opinions on this topic, and they cite one from 2006 and one from 2018, and those both contain the same line. Federal law can provide exceptions to the Public Records Act. We agree. That's a correct statement of the law. Seton was correctly decided. There's another one, though. In 2013, General Cooper issued opinion 13-39, and that one says that government non-commercial uses of copyrighted material are probably fair use, and that if somebody gets copyrighted material belonging to a third party through a public records request, it's basically on their own head if they violate, copyrights after they receive it, and they're going to have to deal with, compliance with the Copyright Act as having received those documents, what they do with them afterwards. That one certainly stands for the contrary proposition that Copyright Act isn't an exception to the Public Records Act. And the ones that, again, my friends on the other side cite don't say anything about copyrights specifically. The ramifications that I've discussed of the trial court's ruling probably explain why my friends on the other side don't attempt to defend the trial court's ruling, which I think is quite telling. Instead, they, on page 61 of their brief, lay out a three-part test for how they think copyrights should apply, and that test doesn't come from anywhere. It's not set out in any case. It's not set out in a treatise. It is not in the Copyright Act itself. It is custom manufactured for the exigencies of this case, and it would, even then, still work most of the evils that I've described. On the question of simply whether or not the Copyright Act creates an exception, the simplest answer to that is set out by the Pennsylvania Commonwealth Court in a 2015 opinion that's cited in Mr. Hammond's brief. And they wrote, "The Copyright Act neither expressly makes copyrighted material private or confidential, nor does it expressly preclude a government agency lawfully in possession of the copyrighted material from disclosing that material to the public. For that reason, Your Honor, there is no exception, and the Copyright Act does not preempt the TPRA in any respect." And I'll reserve the rest of my time for rebuttal unless the court has questions.
I hear none. You have your time for rebuttal. Thank you. Mm-hmm. Will there be one argument on this side?
Your Honor, actually, there will be three,
Three.
if I may. My name is Eric Osborne. I'm here on behalf of the parents. Mr. Rocky King will be speaking on behalf of the school and the church, and Ms. Laura Fox will be speaking on behalf of Metro. I intend to address the copyright argument and the victim rights amendment, the victim rights amendment argument. Mr. King is going to address the school safety exception, and Ms. Fox is going to address the Rule 16 issues and also share Metro's position on copyright, which is consistent with the parents' position.
Have you allocated your time?
Yes, Your Honor. We will have 6 minutes for myself, 6 minutes for Mr. King, and 3 minutes for Ms. Fox.
Okay. You may proceed.
Thank you. May it please the court, Eric Osborne on behalf of Sherrod Rowe. I think this case is actually amazingly simple, and I am happy to stand here and to defend the Chancellor's opinion. I find it curious that opposing counsel would say we did not defend it. One huge key point of copyright law, perhaps the most important point of copyright law, is the right to control publication, including the right not to publish and not display. This is a very fundamental right that authors and creators of content have. They have the right to decide if their material will be made available to the public or not. And the United States Supreme Court has spoken on this issue and has spoken clearly in the 1985 case of Harper and Row versus Nation Enterprises. Now, that case dealt with the unpublished memoirs of former President Ford, and the Nation magazine had obtained certain portions of that and had published them. And in that case, the court was unanimous, and I would really encourage the bench to review that, because there is so much language, 7 or 8 pages, about how important the right to not publish is, how fundamental it is, citing historical treatises going back hundreds of years. Just a few things that I'll note is that—
Let me interrupt you for a second. My larger concern with the use of copyright in general in this case as an exception to the Public Records Act is twofold. Number one, do we, and we being the trial court, whoever hears it, does that not turn this into sort of a de facto copyright infringement action under the guise of being a Public Records Act request? But when the result is the trial court has to decide things like, is there a valid copyright? If so, is the use of it that's proposed infringement? If so, are there exceptions? Is it fair use? And is that what we want our state trial courts to do? That's number one. Number two, if that's the way it should go, did the chancellor in this case even do that? Because it looks to me like she just said copyright exception, infringement, but certainly no analysis of potential defense of fair use.
Thank you, Your Honor. I think the simple answer is that you never even get to fair use when you have an author of an unpublished material who has asserted their right not to have that material published. Fair use comes in when material is out and is weighed at that point. But in this particular instance, the right to publish and the right to make the materials available for inspection, that is effectively what the TPRA sets forth, because it requires that the document custodian give copies of documents.
Well, it requires that the document custodian make them available for inspection.
Correct, Your Honor. It has both. It has both the inspection and copies.
So then you have a whole discussion about whether that is even, is that publication, is that display, is that copying? It becomes a little mini copyright trial that I'm concerned about our level of expertise.
I think, Your Honor, that's
on that.
I understand that concern. I think that's why copyright should simply be an exception, is that if copyright is an exception, because it's a federal statute that governs these writings, then the exception should be applied. That way, chancery courts and trial courts, they don't need to worry about fair use. They don't need to write copyright rules. Instead, document custodians like Metro here, when they come into copyrighted material that's requested, and the copyright owner asserts a right not to have that released, particularly when it's unpublished, it simply needs to be an exception, and that is what the trial courts can apply. And it's a really clean test when you do it that way.
The concern on the other side, which your opposing counsel expressed, is that, hey, now everything is copyrighted material and we don't have to release anything, because you don't have to go through the process to have something declared copyrighted. It is copyrighted. It's just if you're going to pursue an infringement action, you have to do that. But what's to prevent then Metro or anyone else from saying, hey, this is a work, it's a writing, it's a document, it's whatever, created by a third person. It's automatically copyrighted by virtue of the fact that we didn't create it. So we're not going to produce it. It's an exception.
Well, I think that's actually going to be a lot rarer than opposing counsel suggests, Your Honor. Most government records, I disagree with the assertion from opposing counsel today that all government records are themselves copyrightable. I'm not a copyright expert, Your Honor. I'm here mostly to talk about the exception and about what I saw in the Harper case. But I don't think it is correct that government memoranda, police reports, anything like that is copyrightable. You know, this is an extremely unique situation that came about because of what I have called a stupendous act of grace, something we'd never seen before in history, where a shooter's family gave ownership of the writings as a means of trying to help the victims of a crime. So I think that exception
Let me
is not
ask
as
you
broad.
too this,
Yeah.
and I know you've got limited time.
gladly
I've got lots of questions, and I don't think that my questions match our time. But on that issue, there is an issue about who's the proper party to raise the copyright. And it should be is a trust not its own legal entity? And if so, I know the parents are there, and I know the parents, I'm not exactly sure the setup of the trust, but shouldn't the trust be the one to raise these issues?
So the documents that were given to the parents were given to them in trust for the benefit of their parents. So the parents are the owners. They are the owners of the documents. It's just that the parents hold the documents in trust for their children for the express purpose of protecting them by not releasing them.
And once they put the documents in the trust for the trust to hold, does the trust then not become the party in interest?
I don't think that's correct, because I think the parents are the owners of the document. It's just that the document is held in trust, and the parents, on behalf of their children, have asserted their right.
Okay.
We addressed that briefly in our brief. We didn't go into much detail because it was something we didn't think had much credence, Your Honor, but now that I hear it's a concern of the court, we would be happy to provide supplemental briefing if you think that's necessary. So,
We'll research it.
okay. All right, well, thank you. I thank the court for your time. I guess I have 1 minute left. I'm sorry, I thought it was out of time. I will go back just on the Harper case. Justice O'Connor talks about the distinct statutory right of first publication. She decides about the right of authors to decide when and whether something will be made public.
Is your time still pending?
It says 1:11 right now. Oh, am I confused?
That's probably because you've
Yeah.
gone over
Oh,
a minute
I'm sorry.
11,
Okay,
which is my fault, but
I will step down. Thank you for your time. I really appreciate all of you.
Well, thank you, sir.
Misreading the clock there.
May it please the court, my name is Rockland King, and I represent the Covenant Church and will be arguing on behalf of the church in the school here today. The TPRA provides a limited right, subject to numerous exceptions, to public records. One of those exceptions is the school safety or security exception, as we've called it, which is found at 107-504P. That exception provides that any information, record, plans that are related to school security shall not be open to public inspection. Guided by that exception that the interveners raised at the trial court reviewed each and every document. As she outlined, spent countless hours with the diaries of Audrey Hell and her journals, and found that those writings included plans, schematics, theories of how she was going to carry out not only the attack on the Covenant Church on March 27, 2023, but how she was going to carry out other attacks at other potential targets, including Creswell Middle School.
so do we just accept then at face value this idea that every single piece of paper, writing, document, drawing that was obtained by Metro is related to school security?
I'm glad you asked that question, because as the General Assembly has set up the TPRA, the trial court judge acts as the umpire. The trial court judge, the chancellor in this case, is charged with reviewing the documents in camera and conducting a page-by-page analysis and determining whether an exception applies. So under what the General Assembly has set up, the answer is yes, Your Honor. We are guided by what the chancellor has outlined in her opinion. She outlines that those pages include schematics and drawings and plans on how this assailant was going to carry out not only this attack, but other planned attacks against other schools. And under the TPRA, the chancellor is the one empowered to make that determination.
And obviously, you know, a situation where you've got schematics and things that would potentially put the school at risk in the future, information that would not be known to the general public about the building and how it's laid out and how this particular person utilized that to their advantage. To me, that's pretty clear. That's going to relate to school security. I have a hard time grasping that of all of this, lots of material that was recovered, that every single bit of it relates in that way to school security. And I don't know how we review it when there's a blanket finding that every single thing Metro collected is related to school security. We don't have it. We're not going to see it. So how do we review that without an individualized determination for each document.
Well, so, Your Honor, I think we have to balance what Rule 13D of our appellate procedure guides us today. Does the evidence preponderate to a separate, different conclusion? And here, the Chancellor, let's actually look at what the Chancellor did and then a hypothetical to answer your question. The Chancellor outlines that she found specific places, specific plans, specific persons that were targeted. She outlines that the journal entries, the diary entries, contain information drawn upon other shooters and how she was going to mimic other shooters. In particular, the Metro summary says the Columbine shooters were particularly inspirational, and how she drew analogies between that attack and what she was going to carry out here. This is a lot of information, terabytes of data, I believe, here. And so we have to balance what we're hoisting a burden on the Chancellor to do and what is the invitation, which is page-by-page analysis, which I do not believe the TPRA requires. But she made findings of facts, and she is guiding this court on what she saw with her own eyes on that individualized assessment of the record. And she found information that permeated school security issues throughout the diaries and journals of Audrey Hale. This is not a scenario where we got a one-page bench order, which we've all seen from trial courts, and they're perfectly appropriate at times. But in a case like this, we received an over 30-page order delineating her discussion on copyright, but also outlining what she visualized with her own respective eyes. And I believe, sitting in your positions, looking at how the TPR is set up and how she is supposed to act as umpire to apply the law, apply the exceptions, and apply the exceptions when she sees there is an exception to be applied and it's been raised. And that's what she did here. That's what the Chancellor did. She looked at these documents and through her own individual investigation found that school security concerns permeated throughout the entirety of the diaries and the journals, and that it was not possible to pull out different sections and say that this doesn't relate to school security, but yet this does relate to school security.
So then I wonder if the result that we have then, if that's the way we apply it, is that anytime we have a school shooting, pretty much anything that's going to be collected by the police is going to relate to school security because of the nature of it being in the setting of a school.
Your Honor, that very well may be the case, but again, I revert back to the TPRA's language. It requires the Chancellor to actually review the documents. So I don't believe we have necessarily a blanket exception that anything related to school security will be implicated anytime there is a school shooting. No doubt there will be. No doubt there will be likely plans. But in this particular case, the Chancellor, when she took her oath to follow the law, and she did so by looking at these documents. And she outlined it for this court. She gave a record to this court to review and to understand. And when you look at it, you see that this, I see my time has expired.
You
Go
can
ahead,
finish
your
Thank
point,
you.
though.
When you see what she wrote, you understand that she saw information related to school security, that this shooter was inspired by other actions, that she analogized and drew inspiration and information. Frankly, as she says, the writings of Audrey Hale were a blueprint on how to carry out a school shooting. And she didn't want that blueprint to be passed on because of the threat to not only the Covenant School and information uniquely situated as to the Covenant School, but any school. And thus we believe that both legally and factually, the trial court's decision is well supported. And we ask that you affirm that decision. I'm happy to answer any additional questions you may have.
I hear none. Thank you very much.
Thank you, Your Honors.
May it please the court, I'm Laura Fox representing the Metropolitan government. I'm here to answer your practical questions if you'd like. First, let me say from Metro's perspective, of course, this case is in a much different posture than it was when we were at the trial court, when there was an open criminal investigation and the police were very concerned with exposing that investigation. So now we're at a different place. They've been able to trace down every single lead and information that they had. They have determined that this woman acted alone. And so the police, they released a summary investigative report that we've submitted that you could take judicial notice of, which shows the detail they went into in that investigative report. And so I think in that investigation, and so I think that you could either conclude that the Rule 16 issue is moot because it no longer needs to be addressed, or I think you could easily affirm it under the Tennessean case because it was an open investigation and that's what the Tennessean case says. I feel like our issue is really not the most complex one that you're dealing with in this case. As far as the practicalities for a government when they receive a public records request, we do get complicated situations. For example, I mean, some of them are easy, let me say that. Social security numbers, redacted, and a little bit more complicated, domestic violence victims' addresses, because we might have it in a record. It might also be in the Register of Deeds website, and those are records that everybody relies on in the whole county as to make determinations. So there is a lot of complexity. It's not just a copyright issue. But what I've envisioned is that this would be much like, well, I guess I think there's two analogies. One is FERPA, that's Federal Education Protection, and so when we have student records, we do not release those. And that category has gotten broader these days because there are videos of children, there are pictures, they have a digital footprint, and so we have to be very cautious with public records requests for schools that we're not accidentally letting out something through the technology just because we didn't catch it. So I think that's a federal example where I think I've never heard any controversy about not providing those kinds of records. In this case, I think that if someone asserts they have a copyright, then we do the same thing that we did in this case, which is say, okay, well, we're not going to release it. And then if there is a lawsuit, we ask that person who asserts the copyright, you come and defend it. And I don't think that that's wrong to have in state court. I think that our judges are capable of making those analyses if the interested party wants to provide the law and the tools to make them do that.
Do you think that's what happened in this case, though, that there was a true copyright trial determination?
Well, you know, I was reading that trial court order last night, and I think it's absolutely on nail on the head, because the most fundamental right, the number one right, and you know, we live in a community of singer-songwriters. Everybody's got a song in their drawer in Nashville, and all of those folks, if those songs come into into the police's possession, I just don't think that the police are the ones who are allowed under federal law to say, yeah, it's ready to publish, here you go. Even if they look at it, if it's 3 lines of the greatest song ever written, and someone gets to come inspect them, and now they know, I know that, if let's say it's a famous songwriter, I know that this very famous female songwriter, these are her next lyrics. I feel like the cat's got out of the bag. I feel like it's not the right thing that that should be released to the public before the artist is ready. And I think that the case, that the Harper Row case, it involved President Ford, and the newspapers they had gotten a copy of his memoirs before they were actually published. And the Supreme Court said, that is wrong. The very first right is to decide when you want to publish. When you want to publish. So I don't think you ever get to, hey, we want to report on it, we want to have fair use of it. I don't think you ever get to that part until the artist themselves decides they want to publish those documents. So that's how I see it practically working. Do I think that there will be difficult cases? Certainly. But I think that our federal law has prioritized the rights of those artists. And I know that this person in this case is not a learned or well-known artist, but I think we have to think about what would happen if that did happen.
Thank you very much.
Thank you.
Your rebuttal?
Thank you, Your Honors. I'll start with Harper and Row versus The Nation, which was addressed several times by my friends on the other side. That case has 2 notable features. One, it predates Congress's 1992 amendments to 17 U.S.C. Section 107, which explicitly said that unpublished materials can be subject to fair uses. That concept is entirely absent from the Supreme Court's analysis there because it didn't exist yet. And second, nothing in Harper and Row is contrary to or contradicts our contention, actually not our contention, the Copyright Act's very clear mandate that to enforce a copyright, you have to register it if you're an American. Different rules for foreigners. An American has to register his copyright to enforce it. And that goes back to the point I made in our leading argument that the trial court's order here upends the enforcement mechanisms that Congress created for these rights. Notably, adopting the trial court's approach, where the trial court isn't going to examine fair use, it's not going to examine copyrightability in any detail on a document-by-document basis, creates a justiciability black hole. There is no way for the petitioners in this case, or the petitioners in a subsequent case on similar facts, to test the copyright claims and the fair use concepts and the other exceptions and between 107 and 122 in the Copyright Act, to test those under this regimen. You can't test them in the state court because the state court won't entertain them under the trial court's approach. And you can't go file a federal declaratory judgment action because without a registration on the part of the claimant, that action is non-justiciable. You have to have, to file that reverse declaratory judgment action, right? The defendant files the case instead of getting sued. You've got to have a real risk of being sued. And without registration, the claimant can't sue you, and so you can't file a declaratory judgment action against him. So there's no way in this model ever to get these questions answered. They simply go into a black box and no one ever hears from them again. And my friend, Mr. Osborne, suggested that probably most documents the government creates actually aren't copyrightable. That's not true, Your Honor. The concept to which he's referring is the government edicts doctrine, which is discussed in the public resource case out of Georgia about the Georgia Code from the Supreme Court several years ago. And that extended that concept only to legislative and judicial documents, sort of the official work product of judges and legislators. What I refer to as the workaday sausage-making documentation of state and local governments and bureaucrats and people who issue permits and people who do all the sort of ordinary things in government every day, those documents aren't covered. Your Honors, the trial court dealt with 3 and probably 4 categories of documents. It withheld the documents created by Metro and the documents, if there are any, received from the school only under Rule 16, which I think we've agreed is moot. I disagree with Ms. Fox's contention that somehow the court can affirm that now that the investigation is concluded. That issue is clearly moot. There are those documents that withheld only on Rule 16. Those should be released. There are the documents created by the shooter, which the trial court held excludable under the Copyright Act and this school amendment. And I would point the court on that issue to our argument under the Omnibus Bill Clause, which I think completely destroys this idea that you can have anything that has any tangential relationship to school security. That's simply not permissible construction under our laws. Unless the court has other questions, I've exhausted my time.
I hear none. Thank you, sir.
Thank you, Your Honors.
I want to thank all the attorneys for your presentation. This case now has been submitted to this court for resolution. You should receive our opinion and judgment within a reasonable period of time. Again, thank you for your presentation. If there's nothing further, then you may be excused.